All right, Dave, I think we are ready to get going.
Okay, that's great. Well, hello, everybody, and good morning. My name is Dave Zapponi. I'm the Executive Director of ECHO, otherwise known as Educational Council of Homeowners. We are based in San Jose with satellite offices in Tracy and Laguna Hills, California. Thank you for participating in the ECHO live stream event on common problems and effective solutions for small HOAs, featuring Kara Weil. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster a better community and quality of life for associations through education, advocacy, and connection. ECHO is 47 years old, which makes it the oldest association representing collective interests of HOAs in the state of California. It prides itself on providing quality education programs to build stronger communities. Before we move forward with the program, please note this webinar is scheduled for 1 hour and a half. Feel free to leave the meeting at any time. We will mute attendees during the presentation to help with sound quality and to assist the speaker in developing concepts. Please note that we use the chat feature for technical issues and the Q&A feature for content-related questions. You may ask questions throughout the presentation using the Q&A feature. Please be courteous and respectful of the meeting participants at all times. We reserve the right to mute or remove participants at any time and for any reason during the meeting. This program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recording along with the presentation slides will be emailed to the registered participants within 7 to 10 days. ECHO is a nonprofit corporation which has and strictly follows an antitrust policy. It is available for review on our website at www.echo-ca.org. Finally, none of what is said during the meeting shall be construed as specific legal advice from either the speaker or ECHO. If you wish specific advice, we encourage you to ask your attorney. At this time, I'll introduce our speaker for today's presentation on common problems and effective solutions for small HOAs. Kara L. Wild, Esquire, is Senior Counsel and Co-Chair of the Real Estate Practice Group at Ericksen, Arbuthnot. As part of Ms. Wild's practice, she has represented numerous homeowners associations regarding issues related to construction defect and breaches of CC&Rs. Ms. Wild is also a board director of a small HOA association and has firsthand experience with common issues facing many of these types of associations, including reserve funding and member engagement. Kara?
Thank you, David, and good morning, everyone. Thank you for joining us today. Well, so often when we hear about homeowners associations, the problems seem to consist of a fight with the landscaping committee over the type of flowers you can grow, or a heated election with multiple factions vying to serve on the board. But what if that's not your HOA? What if you live in an HOA where the members have trouble filling a board, let alone a committee? What if you live in a small HOA? First, a few facts about small HOAs. Recent statistics state that there are approximately 55,000 HOAs in the state of California. There's currently no definition under the set of laws concerning HOAs, specifically the Davis-Sterling Common Interest Development Act, as to what constitutes a small HOA. But the general understanding is that small HOAs consist of fewer than 25 units, though I've also heard small apply to HOAs with fewer than 50 units. It's been estimated that approximately 68% of common interest developments are 50 units or less, which means that 2/3 of all HOAs are considered to be small. In fact, an HOA may consist of as few as 4 units. This webinar will seek to address the issues facing small HOAs of all sizes. So what are some features of small HOAs? A small HOA may have amenities such as a pool, or might not have any. And if there's a common area, it's likely to be small. The size of the HOA board is generally between 3 to 5 members. A small HOA may be self-managed or partially self-managed. And of course, with fewer units, a smaller HOA has fewer resources for collecting the monthly assessments needed for its operating costs and reserves. That said, though small HOAs have fewer people, they must comply with the same set of laws as the larger HOAs. And that brings us to 3 common problems for small HOAs. The first is recruiting and keeping board members. Second, maintaining sufficient reserves. And finally, managing the HOA. With regard to recruiting and keeping board members, common problems include the pool of potential board members being too small, or being small due to fewer members. Many or even most of the units may have been purchased as income property, meaning that the HOA members live off of the property. And as a result of that, and or other factors, neighbors may not know each other very well. And not surprisingly, many and possibly most of your neighbors have never sat down and read the governing documents of your HOA and don't know what's in them or what they're for. When you have an HOA with 300 to 500 units, it might be a challenge to maintain a board of 5 to 7 members, but not impossible. The potential pool you can draw from is fairly large. By contrast, drawing from a pool of 30 units to fill as many as 5 board positions can be very difficult at best. In addition, the pool of potential members is less likely to give you a wide range of options with regard to certain positions that need to be filled. For example, the treasurer position, there might not be anyone available with a background in accounting, finance, or accounts receivable. Yet the person who fills the role and the board as a whole may nonetheless be called upon to make some fairly complex decisions about the HOA's funding. You might get 1 or 2 board volunteers who are enthusiastic about helping the community and willing to be actively involved. But other volunteers may simply be there to ensure that there's a quorum for conducting business and may not have the time or interest to do anything more, such as join a committee. With regard to members not knowing their neighbors, you may live in an HOA where there's a fair amount of turnover, where people move in and out every few years. Or your neighbors may be tenants, with most of the unit owners living off of the property. The problem is, in order to know the names of all your neighbors, you usually have to have the membership list. And in order to get that list, you have to request it. Even if you do request it, you still might not receive the names of all members because any of them can choose to opt out of being on the list. And finally, one issue you may have at your HOA is that many or most people really don't know how an HOA is supposed to be run. They may have looked at their governing documents when they first purchased their home and likely shut them away in a closet. Very likely your fellow members have not sat down to read the bylaws and CC&Rs from beginning to end, and fewer still are likely to have ever heard of the Davis-Sterling Act. They think their only obligation to the HOA is to pay their monthly assessments. They don't know who's charged with running the HOA, and they don't care. They view living in an HOA, especially condo HOA, as like living in an apartment complex with a distant, unseen owner in charge. The next set of common problems involves maintaining a healthy enough reserve fund to take care of your HOA's repairs and maintenance on a timely basis without having to raise a special assessment. Mainly, fewer members means that less money is available to be set aside for maintenance and repair costs. Unless you approve significant annual increases in the monthly assessments, which most HOA boards don't want to do. Yet the HOA may have significant maintenance responsibilities, such as shared walls or amenities such as a pool. And an HOA with a smaller funding source for reserves is more vulnerable to the unexpected event, such as a weather disaster or a new law that dictates where part of that funding must go. You might live in a neighborhood where your apartment neighbors have new fences, a fancy security system, and extensive grounds. And you and your fellow HOA members might want those things for your HOA. The difference is that those apartments usually have owners with deep pockets, whereas the HOA can only raise funds from the monthly assessments and special assessments of the individual unit owners. Though your HOA might be able to take out a loan to pay for certain items, the members would still be responsible for paying it back out of their monthly assessments or special assessments. Although California law does not require that there be a minimum amount of funding for reserves, it also does not provide relief for small HOAs with big maintenance needs. Rather, applicable law instead requires that all HOAs obtain a reserve study every 3 years, review it annually, and make disclosures about the extent to which the HOA is accumulating the amounts of money recommended by the reserve study. Mother Nature also doesn't care, unfortunately, if your HOA is struggling to raise and maintain sufficient reserve funding. Unfortunately, your common areas and amenities will still age and need repair and replacement. And if you live in a condominium association, you'll need to maintain and repair common roofs and walls in addition to common areas and amenities. Failure to do so could not only result in making your home less attractive and less desirable to would-be purchasers, but could also lead to a situation where the disrepair leads to an injury and potential lawsuit. Audience poll.
Okay, so we'd love to get the audience feedback on this, and I'm gonna go ahead and launch our first poll. Okay, so we'd love to get your feedback on this. The question is, does your HOA have amenities? We'll give just a few seconds to get everybody's responses, and then I'll go ahead and share those responses with everybody. Okay, just a few more seconds, and then I will end the poll. Okay. All right, so it looks like, let me share these results with everybody. So 78 people, that's 70% of our audience, voted yes, they have amenities, and 34 people, which equated to 30%, said no, they don't. So most of you do have amenities, it looks like. Any comments on this, Kara?
We have an amenity ourselves with the pool. I mean, I'd be interested to know how big the HOAs are that do have amenities and how many amenities they have.
Mm-hmm.
And whether we're talking about security or whether we're talking about pools and tennis courts.
Right. Yeah, and it looks like a good chunk of them just didn't have any at all. So that's pretty interesting.
Yeah.
Okay, well, thank you guys for your feedback. Kara, we'll continue on with your presentation.
Excellent. So getting back, so it's even worse when, despite the obstacles you manage to earmark sufficient funds for maintenance needs, and then you get blindsided by the unexpected event. It might be a new law requiring the HOA to allocate funds for something previously not required, such as balcony inspections. Or it might be a pandemic that causes millions of people to lose their jobs and be unable to pay their mortgage or monthly assessments. And they might both happen within a few years of each other. Shocking. Yet, if you don't raise assessments enough to maintain reserves, even if your reasons are understandable, there's no reserve fund forgiveness program. You will need to come up with that money somehow, or face chronic underfunding for the foreseeable future. That could mean a sudden dramatic hike in monthly assessments up to 20%, or a special assessment, both of which are likely to invite considerable pushback from your neighbors. And consequently, I've heard that some HOAs have gotten grants from their counties, but my experience is so far has been no one wants to give me any money, so I wouldn't call the experience universal, and it might be especially tough to get money in this economic climate. Also, bankruptcy is not an option, unfortunately. As was stated in a very good article from Tyler Birding on the ECHO website a while back, reasons include the fact that the HOA is usually its own biggest creditor, and the individual homeowners would be liable for the HOA's debts. Then we get to a third common problem, managing the HOA. Ideally, an HOA would have a full-service property manager, also referred to as a community manager. However, some HOAs either cannot afford full service or can't find a community manager willing to take on an HOA of their size. But full self-management can have problems of its own, from collecting assessments to enforcement of the CC&Rs. If you live in a small HOA, what are your options? Audience poll 2.
Okay, guys, we'd love to get some more feedback from you. Let me go ahead and launch this poll. So we want to know how many units are in your HOA.
This will answer my earlier question.
Hannah, I'm not able to answer the chats or the webinar for some reason. I can't type it in, or the Q&A.
Okay. And polling. All right, so this is, that's because you're a panelist, Dave. Panelists can't answer the poll questions.
Yep.
So how many units are in your HOA? I went ahead and shared the results with you. It looks like we got, most of you are in a 51 plus. Next highest would be 31 to 50, or no, 16 to 30, 21, or 17%. So very interesting. Kara, are you able to see these results on your screen?
Yeah, and what I'm wondering is whether the 51% are the ones that have the amenities that were in the last poll, or whether, yeah, how that breaks down. Very interesting.
Okay, thank you guys all for your feedback. Okay.
Okay, so we've heard enough about problems. Now for that part of the presentation we've been waiting for, potential solutions. As noted on the slide, solutions comes with a caveat. An effective solution does not mean an easy solution. There are not a lot of easy solutions for these issues. How effective the solutions are depends upon your individual HOA's situation, as well as the amount of effort you, others on your board, and or your HOA are willing to expend. First, we'll look at solutions for recruiting and keeping board members, specifically situations where you don't have enough board members for a quorum, you have a board quorum, but need to effectively recruit new board members, or you want to keep directors on your board engaged and invested. The first situation that I described is the worst case scenario. I wrote an article that touches more upon it in the May-June issue of the Echo Journal. It's a situation where you may have people serving on the board, but not enough to form a quorum. Or one person you have that remains on the board is leaving, and soon there will be no one left on the board. This is a serious problem, as a quorum of board members is required by law in order for the HOA to be able to enter into contracts and conduct other daily business. An HOA without a quorum can't maintain their insurance coverage and may have contracts canceled, such as the contract with the community manager. So what if you're one of the sole remaining board members, or a homeowner who just discovered the situation and wants to fix it? What can you do? One option would be to convince the remaining directors to appoint other members to fill the remaining vacancies. Another option would be to convince enough homeowners to attend the annual meeting to form a voting quorum for the purpose of electing new board members. And if the numbers there don't meet the voting quorum required by your bylaws, you have the option of holding a vote anyway and petitioning the court to recognize the lower number as valid. Or if your HOA situation is so dire that it doesn't even have annual meetings or meetings at all, a third option would be that you can call a special meeting on your own to get more board members appointed or elected. Which brings us to the obvious question: what if no one wants the job? My personal belief is that while few may actively seek out the job, if they understand the stakes, what happens if there is no board quorum, and how it could hurt the HOA as a whole, at least a few will agree to serve on the board for a term. Oftentimes, they're not stepping up to volunteer isn't based on apathy so much as ignorance of how an HOA is run and what their role should be. If you explain the situation to your fellow members and no one still volunteers, you can explain further what happens when there's no board at all, which is that a receiver must be appointed by the court. Receivership, as some of you may well know, is a drastic remedy for when there's a complete breakdown of the governing situation, and it's generally viewed as a last resort. A receiver appointed by the court will need to be paid by the hour by the association. So in addition to the HOA paying assessments, they must also pay for a receiver. Furthermore, the association loses control of the ability to make decisions for themselves, and instead the receiver makes them at the direction of the court. The receiver stays until the court is satisfied, but otherwise there's no time limit. Once the other homeowners understand this, then maybe enough will volunteer to serve as board members. So once you have enough directors for a quorum, what can you do to maintain the board? As simplistic as this sounds, one option would be staying in touch with your neighbors. And I know in this day and age that can be very difficult, especially with social distancing, and especially if a substantial number of owners live off of the property. It might require phone calls, a newsletter, or even an internet forum. However, staying in touch would help people feel that they're part of a community and help them be aware of ongoing problems and hopefully make them feel more willing to volunteer for the board. Another option could be quote unquote mandatory HOA orientation. This would involve a group of at least 2 members, preferably board members, visiting with the new owners and letting them know that they're not simply buying a home, but that they're part of a community, and that with the community comes certain obligations beyond simply paying assessments, with the purpose being to maintain their home and their investment. This would have to be dealt with on an association by an association basis, as there's currently no law requiring a mandatory orientation. It would also, I think, do a lot to reduce the amount of fear an individual homeowner might have in assuming governance of an HOA. They might otherwise be thinking, I've never run anything. How can I do this? How can I even understand how this works? What if I mess up? That way, they'll have some knowledge going into a board situation of what's involved, that it isn't scary, and that they don't have to be CEOs or lawyers in order to run the HOA properly. Another option, which falls under the category of drastic, is drafting volunteers. As with mandatory orientation, this has no basis in law. There's no law that permits an HOA board to draft members to fill positions. That said, there's also no law that expressly forbids it. A desperate enough board might try this approach, with the problem being that drafted individuals might not feel the need to actually attend board meetings or be involved with other board communications. Then there's no point to their being drafted. They're just taking up a position and denying it to a homeowner that's actually willing to volunteer. Also, it seems a bit unfair to subject an involuntary board member to potential legal risk, even if most of their decisions would be covered by D&O insurance. Again, in all likelihood, once the members of your HOA understand the stakes, enough of them should be willing to volunteer to fill a vacant position. And just to get pedantic for a moment, as stated in the case Narstead versus Lakeside Village, subordination of individual property rights to the collective judgment of the owners association, together with restrictions on the use of real property, comprise the chief attributes of owning property in a common interest development. And the case then quotes the Florida case, Hidden Harbor Estates versus Norman, which states that with regard to condominiums at least, is the principle that to promote the health, happiness, and peace of mind of the majority of unit owners, since they're living in such close proximity and using facilities in common, each unit owner must give up a certain degree of freedom of choice, which he or she might otherwise enjoy in separate, privately owned property. When it comes to living in an HOA, you're all in this together, as hopefully all members will learn to appreciate. What are some ways to not only keep people on the board, but also make sure that they feel engaged and invested? One way would be to maintain an orderly rotation of board members. Some believe that last year's bill, SB 323, voided term limits for board directors, and the author, Senator Bob Wachowski, has supposedly introduced a Senate bill proposing to add term limits to the list of authorized disqualifications. And if passed, this would not apply until next year. That said, in practice, term limits should be the norm. I realize that for many HOAs, an orderly rotation is just not possible at this time. However, it should be the ideal. It's because you want to have institutional knowledge so that each new board doesn't feel the need to reinvent the wheel. At the same time, if you get someone who's been on the board for 20 years, especially if that person has served as president for a long time, you run the risk of the other HOA members taking for granted that this person will run everything forever and feel no need to run themselves. Or those members might feel intimidated or resent the individual in charge, feeling as though they have no power to remove or replace that person, and distance themselves from HOA governance altogether. You want other board members and HOA members to feel as though, if called upon, they could run the HOA, but they need the opportunity and experience to do that. Therefore, in my view, board members should serve maybe 2 to 3 terms comprising 4 to 6 years tops, or whatever the term limits are in your bylaws, or the term years are in your bylaws, serve that, then just step down. When a board member decides to step down and it's not the natural end of a term, the rest of the board and HOA should receive sufficient notice, at least a few months, preferably 6 months, in order to fill the position. Well, there's nothing in the law, and maybe not in your bylaws, to prevent a board member from stepping down immediately. In my view, unless it's an emergency, it's not a good look and just makes your board look unstable. In addition to making sure there's an orderly rotation, if you're on the board, maybe check in with the other board members and ask them what it is they care about with regard to the HOA. Is it the quiet location? Is it the amenities or the attractive common area? Find out what they care about and want to invest in the long term. Then try to find a position that fits the person and help him or her feel engaged. If they love flowers in the common area, maybe urge them to head the landscaping committee, or is often the case, be the landscaping committee. They might claim it's too much work, but when it's something you love, it never feels like too much work, right? The last thing you want, though, is for board members to feel shut out and discouraged, like their perspective doesn't matter and they're just there to fill a chair. Now let's move on to the next issue, which is potential solutions to raising and maintaining sufficient reserves. For better or for worse, the solutions here are pretty straightforward. The first is, however desperate your HOA might be, try to avoid dipping into your reserves to pay the operating costs of your HOA. While under California law, an HOA can potentially borrow from the reserve fund to meet short-term cash flow problems, such loans must be repaid within 1 year. Additionally, those loans would need to be paid by the homeowners themselves, so you would just be delaying the inevitable by taking out a loan instead of raising assessments. Second, always be on the lookout for reasonable cost-cutting options, such as reviewing your monthly financials for anything that looks like unnecessary spending, or search for contractors or vendors who are well regarded but more reasonably priced. And I've found some success in the past with Angie's List, for example, when looking for contractors. Finally, you may have to just consider raising your assessments every year, even a little, because at least that way you don't have to worry about massive shortfalls that can either cause your common areas to go unrepaired or force you to implement a special assessment. Now we come to possible solutions for managing the HOA. In particular, we'll look at the pluses and minuses of self-management, the pluses and minuses of limited financial services, and the benefits and drawbacks of full service management, if it's in the budget. If you're a small enough HOA, you may be asking yourself, why do I even need a community manager? As a result, many small HOAs are fully self-managed. The most obvious benefit to self-management is that you don't have to invest precious funds in hiring a property manager. That said, there are a lot of factors that need to be taken into account when making the decision of whether to go with that option, including the risks, such as what is the size of the HOA and the amount of property to be overseen. If the HOA has, say, fewer than 10 homes, then there's very little in the way of common area and no amenities. Self-management would likely be much easier than for a larger HOA with those things. Next, whether the board members have the free time to devote to overseeing the property, from making certain assessments are paid and the funds properly allocated, to enforcing the CC&Rs, to coordinating with vendors to perform necessary maintenance and repairs. Third, whether board members are well positioned to collect assessments and enforce the CC&Rs consistently. Fourth, whether the board members are sufficiently knowledgeable not only of the CC&Rs, but also the requirements of city, county, and state laws. Fifth, whether the board members are willing to maintain their education on applicable laws and seek out legal counsel where necessary. And finally, whether the board members are comfortable with taking on more risk and potentially increasing the likelihood of lawsuits against the HOA. Some small HOAs aim to save money by even trying to perform maintenance and other tasks by themselves, not even retaining a contractor or a vendor. The problem here is if a board member or HOA member gets injured, that person could file a claim against the HOA, as he or she might not be covered by his or her own insurance, unlike a vendor, and wouldn't be covered by the D&O insurance, as it would be going outside the scope of that person's board role. The work they seek to perform may require a license, surety bond, and/or specialized training. And if the work is later found to be deficient, the HOA could be sued for negligence, and they couldn't be indemnified by a third-party contractor. However, if you, However, if you've weighed the options and determined that self-management is the best and only option for your HOA, some tips would be always keep, actually, hold on one moment. I think maybe you were on the right slide. Yes, there we are, okay. Always keep organized, up-to-date files, including financial records. Consult with outside professionals, including certified public accountants and legal counsel to stay compliant. And finally, do your diligence to stay informed about the law and any changes in the law. That includes belonging to organizations like ECHO and attending their seminars. And just to note, if you have a lawyer on your board, that does not take the place of needing to consult with an outside attorney. The lawyer is acting in the role of a board member, not a professional attorney. To do so would be for that person to go outside his or her board role and potentially risk liability. And also, if you're still determined to do it yourself for small performing the task, to agree to sign a waiver stating that if he or she's injured while performing, he or she waives the right to file a claim against the HOA. If you don't want to fully self-manage but feel you can't afford full service management, another option would be limited financial services. Many community managers offer limited financial services only, consisting of accounts receivable, collecting monthly assessments, and keeping track of who's not timely, while the board is responsible for everything else. This can be a good option for HOAs that are really cash-strapped, but would struggle with the responsibility of keeping track of assessments and financials in accordance with the law. However, that also puts the HOA board in a position where you have to do everything else yourself. That might work if you have a bunch of board members who have lots of free time, knowledge of the law, are proactive, and are reliable and willing to assume more risk. Unfortunately, that's not the situation of a lot of boards. Here's why I think a full-service community manager is your best bet if you can afford one. They'll handle all the accounts receivable and work with vendors and contractors. At the same time, if they're good, they'll be knowledgeable of the law and know how to keep the HOA compliant and advise the board of such, though you should still consult with outside counsel where necessary. And ironically, this is probably the best option if you have trouble keeping board members for very long and can't rely on the deep knowledge and steadiness of one or more board members when deciding whether to take certain actions. When you have an HOA board with high turnover, there will likely be more inconsistencies. It could be difficult to figure out who's at fault for certain failures and to hold certain board members accountable because they might already be gone from the property. Whereas by contrast, a good community manager generally lasts longer and will leave a paper trail and will get finances audited as needed and more. That being said, the property manager or community manager is an agent, so board members shouldn't seek to abdicate their role, their oversight role to the property manager. It's a great resource, but you still need to use your own judgment. But that's a discussion for another time. So how to find a community manager if you're small? Personally, I wish you could just Google the top 25 property or community managers for small HOAs in California and find what you need, because trust me, I tried. Instead, I found that there's no one reliable way of finding a community manager. My method generally involved a mixture of cold calls, word of mouth, and internet searches. And honestly, I wish I'd known about ECHO at the time, or I'm sure I would have gone with their professional service provider directory as well. And I definitely would obviously recommend that. But once you have some names, set up a time to talk and interview potential candidates. Ask up front what size HOAs they represent, and then what they charge for servicing an HOA your size. There's no point in falling in love with the services they offer and then finding out they can't take you because they only represent HOAs with 50 units or more, or you can't afford the cost. Ask a lot of questions, particularly how interested in your HOA are they? Find out how willing they are to spend time and address your issues. I haven't found that I've had to sell the benefits of managing my HOA to a community manager, as I've heard some have had to do. Maybe that's more of an issue for an HOA with fewer than 10 to 15 units. But then if you find a management company that you like and the feeling is mutual, make a list of what you'd like to see in terms of service. Be realistic about, in terms of what can be done in the amount of time, and account for a transition period. Then check your list at the end of the first year to see how well those goals are being met, and discuss with the board and the manager how to move forward. So we've had a chance to discuss a variety of options that you can take for your small HOA. These are suggestions, and not all of them may meet the needs of your specific HOA. While hopefully many are helpful, there are limits due to the fact that there is no set of laws that holistically address the circumstances of small homeowners associations. Too often, where the law does provide a solution, they're often cumbersome to implement, or the law fails to provide an enforcement mechanism. Hopefully, future legislation will address these issues. These are some of my thoughts, just pure brainstorming thoughts, on some potential advancements that could help small HOAs. The first might be if small HOAs struggled individually to form a board, that they be permitted to legally form a master board with several small HOAs in the community. Now, to some extent, this already exists. Most typically, you'll find it where you have one building containing multiple condominiums that's separated into multiple HOAs. And the individual boards of those HOAs vote to have a master board that oversees the common areas. Those HOAs, though, have full boards in addition to the master board. The board the boards then delegate some of their authority to a master board, which coexists alongside the individual HOAs and boards. But what I'm referring to specifically is combining HOAs that are not already part of the same building or general community. For instance, what if there were several small HOAs in one city that have chronically struggled to fill enough seats to make a board quorum? Under this scenario, they could potentially agree to combine, and a few board members from each association would form a master board and oversee functions for all the HOAs. These HOAs might not even be in the same city. They might be just in the same county. Obviously, there would be a lot to figure out in order to make this a viable option, such as how would the governing documents need to be amended? How alike would each small HOA have to be in order for it to work? Would they have to have the same number of units? Would they have to have similar assessments? Would they need to all be on the verge of receivership? Also, how would the reserves and overall budgets for each HOA remain separate, or would they be combined in some fashion? Would the community manager be the same for all of them? Would this require a majority of members to approve? And what happens if one HOA has more board members than others? It's a lot to work out. However, it could be an option to prevent HOAs from being chronically underfunded and deteriorating. A receiver might fix the situation in the short run, but this is meant to be a longer-term solution. Another potential change would be to enshrine in law my earlier suggestion about drafting board members. It would permit HOAs to amend the governing documents to inform new buyers that they must accept that they have obligations to their HOA and that they may at some point be drafted to serve on the board. If at the time they're drafted, they don't wish to be, they must provide a good faith reason within 45 days of receiving notice. And if they fail to provide a reason, then they're members of the board for a 2-year or however long year term. Then if these board members don't attend meetings or perform at least minimum functions of a board member, the law would permit the HOA to assess penalties against non-performing board members. This would be controversial to say the least. Plus, it would need to be determined whether it could be applied retroactively or would only apply to people who purchased units after the law took effect. That said, it would be another way to ensure that your HOA always had a functioning quorum. Another less dramatic option would be if the law were changed to mandate that any seller's agent or buyer's agent provide the would-be buyer of a home in an HOA with mandatory education regarding what that would involve. Most homeowners on their own couldn't figure out what a reserve fund is, let alone what percentage of funds it needs to stay healthy. Or for that matter, what monthly assessments are paying for. Under this proposal, a mandatory education would include discussing the health of the HOA's reserves, what a reserve fund is for, and obligations for maintaining a board quorum, which could involve serving on the board. Such a law would have to lay out steps for how this could be achieved so that the buyer and or seller's agent could potentially avoid liability. Likewise, such a law could mandate that homeowners already in HOAs be required to, say, attend at least one board meeting per year and to attend an annual seminar on changes and updates to HOA laws. Though obviously there would be complications, of the options discussed, this one to me feels like the most realistic and doable. Although I've heard that supposedly there's discussions in the work to try to make something like the master board situation I just discussed a reality, and I would be very interested to see how that goes. Another option would be to be able to amend the governing documents to appoint someone to serve in a semi-permanent position that would be like a receiver. But the difference would be that this would be a salaried or stipend position, and the costs would clearly be baked into the assessments, which would be higher as a result. This highly trained individual would be the face of the HOA rather than an agent, and would essentially act in the role of a board. This could be an option that acknowledges that most HOA members do not have significant legal or financial knowledge. The issue here would be how this person would be appointed, who this individual would be, for how long would the appointment last, and what to do in the event that members are unhappy with this person's decisions, as well as how to hold the individual accountable if he or she acts in bad faith. Finally, other advancements could involve Davis-Sterling and/or the Corporations Code acknowledging the realities of small HOAs and therefore providing exceptions for where it would be overly burdensome for a small HOA to fulfill certain requirements. Right now, while you have the option of appealing to the court in certain situations, that in itself can be burdensome and a time-consuming process, which can be a problem when time is of the essence. Again, overall, this is brainstorming. I'm not aware of whether most of this is already potentially being discussed by the lawmakers in Sacramento, but I think the situation calls for creative thinking and recognition that because HOAs are such an affordable and popular choice in California, they're not going away. We need more options than we currently have for how to make governing them more manageable.
Okay, so now, thank you, Kara. We are going to jump into the Q&A session. Looks like we have quite a few questions, so we'll try to get to as many as we can.
Answer them.
What was that, Kara?
I'll try to answer them.
Yeah. Okay. Let's see.
Thank you. Thank you, Joby.
Can you have 3 types of use: owner-occupied, rental, and opt-out, or are there only 2 types: owner-occupied and rental?
My specific HOA, I've only been aware of the 2. I'm not familiar with the other scenario. I mean, in my particular HOA, we have a lot of rentals. I'd say approaching half of all the members live off the property. So I'd have to sorry, I can't answer that question in its entirety at this time.
Okay. Continued on opt-out owners, end of question. Can all members see their information even if opted out of the list?
Oh, I see what you're saying. I'm sorry, can you repeat that?
So continued on the opt-out owners and, oh, I see, there's a question right above it. Okay, this makes sense now. Can opt-out members be also opted out of any information such as, is their unit rented? Do owners live there? Can members have access to this information if only the use is continued on opt-out owners?
I'm only aware that they could opt out of being on the membership list, which would state their contact information. I'm not aware of at this. I'd have to take a look to see whether they could opt out of being anything else.
Okay. What if your on-site manager gives permission to a group For example, pickleball players, the use of common buildings all day and all month, which is against common use building rules.
That's not good. They're supposed to be, your agent should be complying with and enforcing the CC&Rs, and if your CC&Rs don't permit this, and I would ask, is the board aware, and did they permit a special exception, or is this just something that's going on without the board's knowledge? I think, I need those facts to be able to answer more completely, but generally, I mean, the property manager is the agent of the board. So they should be in touch and discussing issues with each other, including whether to permit building access.
Okay. So for board members, any advice or maybe anything that you might have experienced if they're just being inundated with constant emails from people, how have you found to better, I don't know, manage that type of situation?
I wish I could say I had a great solution. I think it's positive that at least they're getting feedback from their HOAs about issues they're having. It might be easier to have one person be the contact person, such as the president, however unwilling he or she might want to be the focal point, just so there's not some disorganization going on there, where maybe it goes to the secretary and secretary forgets to forward it on. So have like a focal point, like the president, receive emails, maybe have a special email so that they're not bombarding like their personal email, and then maybe that can be that way the board will see it and be aware, but then they could forward it on to the community manager if necessary, or at least have an organized organized way of dealing with these issues, to the extent they can.
Okay. And Kara, any thoughts on how to keep a board unbiased?
Unbiased as in is it personal bias, racial bias? Is there any?
They didn't give any indicators. It just says unbiased. I'm assuming it's just personal bias with maybe things that they probably feel are important that maybe the other homeowners don't, or things that's they didn't really specify, but this seems like an interesting question.
Well, what I'd say, whether it's personal bias or racial or otherwise, and you're not a member of the board, attend board meetings, use that open forum to discuss general concerns you're having about things you might have observed. And if your board's receptive, they'll either say, okay, duly noted, we'll make that change. Or they might even, if it's a deeper problem like racism or sexism, you might suggest that there be training. I would say actually though, when it reaches that point, you might want to consult outside counsel for your particular board's situation, to determine like whether training or sensitivity training is required. But overall, I would just say, you're not a member, or you're not a member of the board. Go to those open, go to the board meetings, go to the annual meeting, use your opportunity to state your piece during open forum. You might also potentially ask one of the board members whether you can place that as an item on the agenda to discuss if you feel like your 3 minutes or whatever during open forum are not enough. But those are your options, and if the board doesn't care, you always have the option of running for the board yourself, or at least trying to replace those board members with perhaps people who are a little more open-minded and enlightened.
Okay, thank you. And can a board exist if 4 out of 5 board members resign? Can a single board member continue to operate as a board if all others resign?
No. The answer is no. It is not a board anymore if you don't have a quorum. What you have is just one remaining officer. And I already outlined in my presentation what happens, what you can do to regain the quorum. Because without a quorum, you're not recognized. You can't be considered a legal entity that can do business, and so that's why you really need that quorum. But luckily, the law gives you a remedy of being able to the remaining board member being able to appoint other HOA members to fill the positions to create, so you have enough to create a quorum. And that way, if you have an HOA that's just so dysfunctional or just apathetic or whatever, you don't have to worry about getting enough of the voting members to show up to elect a board. You can, if time's of the essence, you can just appoint people. And I mean, this is where obviously drafting board members would really come in handy. But I think if you're a close enough, small enough HOA, hopefully the remaining board members, or the one remaining board member, can just have a discussion with other HOA members as to what the situation is. Then they'll understand, and they will step up to fill they'll allow themselves to be appointed to fill the vacant seats.
Okay. Next question, Kara. So if there's really, really old governing documents, in your opinion, what are some of the benefits of amending them?
I mean, I think the biggest benefit is obviously you want consistency, and if they're old enough, then you're going to reach a point where there's some big inconsistencies with the law, and it makes it a struggle to also to comply with the law and to also comply with your bylaws or your CC&Rs. Although if there is a question of which one dominates, it's usually the law, unless the law makes an exception. But you don't want to have to try to navigate those inconsistencies and try to figure out, okay, this in my CC&Rs is no longer valid because this law forbid it 10 years ago.
Gotcha.
So it makes things easier for you if everything is consistent. And my understanding is that probably every 5 years is how often you should update your governing documents, or at least your bylaws and CC&Rs if you can. And if you go more than that, you might want to consider not just sort of selective updates, but a wholesale update, just to ensure that nothing's forgotten or left out.
Okay. And in regards to reserve funding, do you recommend that it be kept to close to 100% funded, or what is your recommendation or experience with that?
That would be amazing. Funded. My understanding, my ballpark figure is that anything below 30% is considered to be in danger zone, could have a special assessment assessed, and that you generally want to be at or above 50%. I mean, if you can get 100% funding and maintain that, even with big projects, then that would be fantastic. And you should be aiming for as robust a reserves as you can. But in terms of if you can't get there, like you keep having to dip into the reserve funds to pay for large scale projects, like large scale necessary maintenance and repair, then I mean, my knowledge at least is at least 50%. And you may just want to consult with your local council if you have more questions about that. But that's just what I've always known as a board member. You don't want to get to that below 30% point, because then you might not either be able to fund major repairs, or you might have to raise like a special assessment of who knows how large in order to fund them.
Okay. If there's nothing in the HOA's bylaws on terms, do you recommend that they just go with SB 323? Or I think you mentioned it being the ideal. So if it's not in their bylaws, what do you suggest?
I think it should be a voluntary thing. I think even if your board doesn't, your bylaws don't specifically state that there be term limits, I just think as a general practice, it's a good idea. Just because, again, I mean, in my experience, people often join the board. I mean, they're not so much because they want the power or they're super excited, but just because they feel it's necessary to keep their HOA going, especially in a small HOA situation where it might be hard to fill positions otherwise. And they view it as a responsibility. But the danger there could be that they end up feeling trapped, like, okay, now I'm, board president or board financial officer or what have you, and I'm here and there's a quorum and everything's great, but no one else seems very interested in taking on my role, and so I'm just stuck. I'm stuck here. Basically until if I step down, it's possible that no one else is going to want to continue to serve, and we might have to appoint a receiver after all. I mean, so it's my thought is it's just to kind of help people set the expectation that this person's serving now, this person's going to step down. They're not the person who's going to be in charge forever, and soon it'll be your turn. It's just part of being in an HOA. It's not a horrible, scary, or strange thing. So that's kind of a long-winded answer to that question. But it's I would just say, as a practice, consider it. Just so people who are kind enough to step up don't feel like they have to be stuck there for the long term if they don't want to be.
Okay. How can a board compare what their manager is providing to what other boards are experiencing?
That's actually an excellent question, and I wish I knew the answer better. What I would say is ECHO, belonging to communities like ECHO is great because you get to interact with other board members at various functions and lunch events and what have you. And I mean, that's where you can just talk, and you can talk and share experiences about your experience with a particular community manager. And also there might be things like Nextdoor that have HOAs as your neighbors, and you might get to talk to people through there and find out information. But I mean, that's an ongoing issue for me as a board member. I'd love to just have more interaction with other board members and just find out their experiences and with a variety of things. And apart from ECHO, I haven't been incredibly successful with finding those types of communities.
Yeah, so I think on our part for ECHO, most of that would be in our resource panels. So those are, we were doing them all in person before all of the pandemic stuff happened. So those were in-person meetings. They were really informal lunch gatherings, and we are now moving them to virtual resource panels. So we're still, have the interaction, but those are the best ways that I know of, and like Kara mentioned that she knows of, to really get in touch with other board members and have those conversations. So it's a little bit different than this type of setting where there's not a lot, the only speaking parties are, our panelists and our speakers. So our resource panels are a great way to hear from other board members, and there's vendors that attend them and community managers. So it's kind of a little bit of everybody in one small group. Let's see. There was one I saw that I really wanted to ask, and now I lost it.
Yeah, Hannah, I may have answered it, typed in an answer.
Okay.
I've been answering, there have been a huge number of questions.
Yeah, we have 41 answered and still 54 unanswered. So if that gives you a perspective of trying to, find questions that would really benefit the group as a whole. But thanks, Dave, for handling some of these, because there's quite a bit.
I may have jumped onto one, so you'll see some of them going.
Okay. Are there any changes in laws for who can be a board member, a proxy, something to help?
I know there were changes in the election laws, supposedly, that you might want to take a look at. I know that one of them, like, you have the chance to disqualify somebody who's been a board member been a property owner for less than a year. From running to be on the board. That you have the option, but you don't necessarily have to. So I would encourage you, what I would say is I'd encourage you to look at the recent election law changes made to the Davis-Sterling Act.
Yeah, Kara, I can add a little bit. The new law actually made it easier for people to run for the board, and because there are much fewer limitations on the reason a person can't qualify to run for the board. The one you mentioned, you have to be at least a homeowner for 1 year in the community. Another one is that if the person who's running may have an impact on whether the association can get a bond or not, that is insurance or not, that's another reason. And that would speak to their character if they've been arrested for a crime or something of that nature. But other than that, just about anyone who is a homeowner can run for the board. And there are a couple exceptions, but most of them aren't relevant to most communities. But we do have the statute book. You can get it online at ECHO's bookstore. And it is also downloadable for members for free. We sell it to members and non-members, both members as a book, and that's $20 for members and $25 for non-members. You can also get it online with the state of California. Just go to their website and go to the code, and that's all public information.
Great, thanks, Dave. When When does an HOA need to pursue a receivership? My 48 unit has members, lack of interest, and board not engaged to actually take the HOA from the dire condition.
I believe you can petition for a receiver. I mean, if you feel like your situation's gotten so dire that it's falling apart and the board, if the board even exists and, in the sense that there's a quorum and there's meetings, if they don't seem to care, the law gives you the option of petitioning for a receiver, and who could then potentially step in. But usually the situation where a receiver will come is when there's no board, and your contracts are canceled and everything's falling apart. So that's to my knowledge the main situation with when a receiver steps in.
And so can people or homeowners lobby the membership to vote board members out of their seat? Is there any legal implications or other implications that you're aware of?
I mean, there are, if you're talking about like election media rules, I mean, you could look at those in terms of, the election rules for Davis Sterling. But I mean, in terms of just talking to your neighbors and saying, hey, we're really sick of this person. I'd love to, vote for anyone else. I don't think there's any limitation to that.
Carrie, in fact, in 2019, the law passed to allow more political activity in communities, so you can do that.
Great. Let's see. You mentioned the wholesale earlier for redoing the governing documents. Did someone ask about a ballpark price? Do you know of any for that?
Any firm is going to have a different answer.
Okay.
I heard 5,000 as one number for whole scale redrafting, but it really depends, I think, on the particular firm you go to and how much updating your governing documents need.
Okay. And if somebody's a board member, do they get a free pass on their monthly assessment?
Not that I'm aware of. I wish. No, we have the same requirements as any non-board member. We don't get paid. We're exactly the same. We're just volunteers who want to help our HOA.
Yeah, there's one other component to that. If they're not paying their assessments and no one's enforcing it, and they're saying, well, I'm a board member, I need something for being on the board, and this is what I'm taking. That's in essence compensation. Right. That changes the nature of the corporation from, so those people are piercing the veil, or potentially could be piercing the veil of their D&O insurance, which is voluntary. And there's laws on the books now, they've been on for a long time, the Good Samaritan laws, that if you get paid, it puts the whole community at risk, and that would be considered payment.
Okay, next question. We got time for a few more. So if the whole board, if they all speak English, and there's a large number of residents who English is a second language, do you have any experience or advice for trying to communicate information to the residents that don't speak English?
That's an issue that I think is that we're familiar with as well. What I would say is, obviously, if you could get, if you have someone on the board who potentially speaks, another language, that would be helpful. Obviously, if you could get an interpreter in certain situations, that would be fantastic. Lots of times, maybe they have a family member who speaks English. You can communicate with that person. But no, I mean, that has been an ongoing issue that we're dealing with as well, and we've tried a variety of approaches.
Okay. And I don't recommend using Google Translate either.
No.
It doesn't always translate correctly. So my experience is don't use Google Translate.
Right. Yeah, do not.
What are the repercussions for a small HOA who do not have a reserve study each year?
I mean, one issue obviously is that you don't know what components need to be. I think it has to be. Yeah, I mean, you don't know what components are need to be replaced, what their useful life is, and if you don't have reserves, you don't know how much money could potentially be needed to be set aside to repair and replace. And so you might be blindsided by suddenly your entire roof needs replacing, and that's going to cost $100,000 or more. And because you didn't have a reserve study to sort of help you know what to put aside, you might have to really, you can't even make that money through raising monthly assessments. You probably have to raise a special assessment to a pretty significant amount to try to cover the costs right away. So, I mean, what a reserve study does is it gives you, sort of a roadmap to follow in just preparing for these major changes, major upgrades and repairs. Without that, you're flying blind to a large extent.
Okay. Can you prohibit recalled board members from running again?
Oh gosh, there probably, I'd have to check the election rules or to see whether that is in the law.
But Kara, I think the only way you can actually prohibit someone from rerunning again is if they have violated one of the components of the law in the Davis-Sterling Act on whether they qualify to run. This is the problem we run into a lot of times when, and this happens all the time for us. A group will recall the directors will rerun on the same ballot in the same day, so they get recalled, but they also then get put directly back on to the board position, and it happens all the time. So if you're going to recall a board, make sure that you have viable candidates that are going to run and be on the ballot, the recall ballot, and that way you can avoid it. But no, they can go right back and run unless there's a reason otherwise in law that disqualifies them. And the law, as I said earlier, is much broader.
Yeah.
Great, thank you, Dave, for that. Let's see, Kara, or Dave, do you guys see any questions on here that would really benefit the group as a whole? I'm trying to scroll through them the best I can and try to.
Well, I'll tell you, there are a lot of questions, and most of them are really good. I just don't think we have time to respond to all of them. So I think we're kind of getting to the end here.
Yep. Okay. Kara, anything else that you see, or any last comments before we finish up?
Let's see. Things I would love to answer, but it seems like it would take longer than we have.
We might have to do another one.
There's always so many questions. And
I can't choose a favorite.
And again, everybody, Kara did kindly provide her email address that she said people can email her about, and she will do her best to try to answer them. And again, that's right here on the Q&A session screen. Okay. All right. Well, Thank you, Kara. Thank you so much for your time and experience and expertise on all of this. I know just from reading the comments, and everybody was really, really thankful, and I thought it was absolutely wonderful. I think a lot of what you said was really relatable to people that are going through situations just like you described. So thank you very much, Kara, and thank you for everybody that has attended. And we greatly appreciate you and supporting ECHO and joining us and using our education to build stronger communities.
So okay, go ahead. Are you going to go through our upcoming events here? Great, sorry.
Yeah.
Go ahead.
So we do have even more webinars coming up. Again, July 10th, Successful HOA Community Engagement. So we're going to dive even deeper into the engagement aspect of HOAs and engaging your community. That's with Julie Adaman, and she will also be doing another presentation on what to do as a new HOA board member. And that's on July 17th. And then July 30th, we have HOA Insurance and Liability with Elliot Katzovitz and Sandra Gottlieb. So these registrations will be coming up very, very soon. So be looking for those in your email and as well on the ECHO website under events. Those are some really good ones coming up as well. So we're trying to get as much information to you guys as we can. And also, if you are not a member of ECHO, we really encourage you to join. There's some great benefits of being a member of ECHO. And if you're interested in to know more about that, feel free to email jprice@echo-ca.org or call our office at 408-297-3246. You can also find more of that on our ECHO website. So we'd love to have you join us and be a member of ECHO. And Dave, any last comments before we finish up?
Thank you, Hannah. I'm sorry I interrupted earlier. The one thing is we do have an info line at ECHO, and you can send your questions into us as well. There are 14.7 million homeowners in HOAs in the 55,000 HOAs in the state of California alone. So sometimes we're not able to respond to all the questions, but we will do our best. We sure hope to have you all join ECHO, and especially you might want to sign up for our ECHO Insight, which is our online newsletter available to anyone who's in the HOA world. So thank you all for coming and participating today.
Yes, thank you. And just that email address that Dave was just mentioned, it's info@echo-ca.org. And we hope to see you guys next time, and thank you all for joining us.
Thank you, Kara.